Yeah.
Good morning. 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no eating, sleeping, talking, gum chewing, or reading material. Thank you.
That's that 647 is not on in there. Is it 647?
Oh, yeah, but you know what? There's some paperwork in here.
Oh, that's one. Okay.
All right, this is case number 24152647. This is Rodney Chiropractic versus Citizens Insurance Company of Midwest. The matter is before the court set on for a pretrial conference. I did set the matter over for review on today's date. Your appearance for Rodney Chiropractic, please. Mr. Porter.
No, I believe Mr. Fortner will be on very shortly. If we can just skip along, he should be over here any minute.
All right, thank you, counsel. Thank you, ma'am. Do I have counsel for citizens? Counsel for Citizens Insurance? All right, I'll come back to that matter. Sure. The court now calls case number 24159450. This is Calvary SPV1 LLC versus Antonio Alvarenga. The matter is before the court, set on for a motion hearing. All right, your appearance for Calvary, please.
Yes, Your Honor. Chris Royce, P49102 on behalf of plaintiffs.
All right, thank you, Mr. Royce. And I understand that, that there is a language barrier. Do I have an interpreter on this Zoom? All right, so do I have Mr. Antonio Alvarenga on this Zoom? All right. All right, thank you, sir. Good morning to you. So, sir, do you speak English, Mr. Alvarenga? Are you able to speak English, sir?
Yeah.
You're muted, so let's get you off mute there.
Excuse me, Judge. The interpreter was there.
All right, just one moment. Do I have the interpreter on this matter?
Okay, thank you.
All right. I don't see the interpreter, although I've been informed that the interpreter was here. So, Mr. Royce, I'm going to come back to this matter and see if we can drill down on who the interpreter is. And Mr. Alvarenga, I'll be back to this matter shortly. All right. This is case number 4166940. This is United Fund CCR LLC versus Jalen Rawls. The matter is before the court, set on for a status conference. The court is in receipt of the defendant's answer. The complaint in this matter alleges damages of $2,442.46. Your appearance for due fund.
Good morning, Your Honor. Attorney Kurt Coco, P54468, appearing in place of the attorney of record and for the plaintiff.
Thank you, Counselor. Good morning to you. I'm looking now for Mr. Jalen Rawls. If you're on the Zoom, please say something at this time, sir.
This is Jalen Rawls, present, Your Honor. How are you today?
I'm great. Good morning to you, Mr. Rawls. All right, Counsel, I know that I have this set as the first hearing regarding this matter. Update me on where things are at this time. Best of your knowledge, sir.
Of course, Your Honor. Well, ultimately, we were at a loss as to what the dispute may or may not have been, as we didn't receive a copy of the answer, but I had an opportunity to speak with the defendant, and I think we have a resolution where the defendant will agree to consent judgment for the full amount payable at the rate of $150 a month.
All right, when did the first payment be due on that matter?
I leave that to the gentleman defendant. What would be good for you? Is the first of next month acceptable?
The first of next month should work.
So June 1st falls on a Sunday. I typically like to put these things like on Friday, so we can put it June the 6th, the first Friday in the month of June, and then we do every first. That makes sense to you, Mr. Ross?
Yes, Your Honor, that works great. Thank you, sir.
And it is your agreement to enter in the judgment for the full amount with the understanding that that you would pay it in increments of 150. Correct, sir?
Yes, Your Honor.
All right, all right. The court finds that there is in fact a consent, and I will await the order on this matter, and the notification is made. So the best to vote today.
Thank you.
Just one moment. My apologies for the interruption. All right, we're on the record now regarding 24175698. This is LBNB Funding LLC versus Brittany Ambrose. The matter is before the court on the following motion for summary disposition. I do have to set as a pretrial conference. All right, your appearance for the plaintiff at LBNB Funding, please.
Good morning, Your Honor. Attorney Ashley Nonis Hartman, P77029 on behalf of plaintiff.
All right, thank you, Ms. Hartman. Good morning to you. I'm looking now for Brittany Ambrose. If you're on the Zoom, please say something at this time.
Brittany Ambrose here.
All right, thank you, Ms. Ambrose, and good morning
Good
to
morning.
you. I do see where the motion for summary disposition regarding this matter was filed on the 18th of March of 2025. I don't see a written response to the same. Counsel, update me on where things are at this point.
Judge, exactly what you said. We filed our motion for summary. We have not received a response, so we're ready to move forward on our motion.
Got it. And have there been any discussions today or anything about trying to reach any resolution on this?
No, Judge, I think at the last hearing we attempted that and didn't have any resolution.
Thank you. And Ms. Ambrose, I don't see, as I've indicated previously, a written response regarding this matter. So I'm going to go forward with the motion. I will give you a chance to respond to the things that Ms. Hart will bring to the attention of the board. Ms. Hart, you may proceed at this time.
You said I
Thanks,
need a
Judge.
response, or she does?
I'll give you an opportunity to respond verbally, but you're supposed to file something in writing in response to this motion. But let me hear from the attorney, and I'm going to come to you to see what your response might be in this regard.
Thanks, Judge. So in September of 2022, the defendant opened up a Credit One credit card account. She made various purchases and did also make payments. However, payments ceased. Her last payment was made on February 26th of 22. Since no further payments were made, the original creditor, Credit One Bank, charged off the account and sold it to my client, LVNV Funding. The defendant filed an answer essentially admitting to the account, just stating that she could not afford to repay it. So based on the pleadings alone, we're entitled to judgment under MCR 2.116I1. Under MCR 2.116C9, the defendant doesn't present a legally valid defense. And then obviously under MCR 2.116C10, there is no genuine issue of fact. So we would ask that our motion be granted.
Well, thank you, counsel. Ms. Ambrose, in response to is there anything you wanted to tell me in response to this motion, ma'am?
I don't understand everything, but I did file a bankruptcy on May 14th. I don't really know how to answer. I don't know.
All right. So I have not received, what happens is that when you file a petition in bankruptcy, typically the attorney will notify court or give notice to the other side. The bankruptcy will stop the proceedings. But I don't have anything that's been submitted to the court that indicates that there is a bankruptcy at this time.
I'm looking it up right now, just to verify, because if there is one, then obviously we would file the admin stay. It looks like as of Pacer, you said, Ms. Ambrose, you filed 514.
Yes, 5/14/2025.
Okay, I do see that, Judge. So what we'll do is we'll file the admin stay.
I'm sorry, Ms. Notice, Hartman, you said something and it sounded a little bit muffled. You said something?
Sorry, Judge. So I'm checked Pacer right now. I do see that the bankruptcy was filed. We didn't receive notice of it yet, but I will get the administrative stay, excuse me. Sorry, Judge, to the court.
All right, very well. So, Ms. Ambrose, we've been able to verify that there has been a filing, and so that stops everything at this time. And I will await the paperwork that will stay in this case pending the outcome of bankruptcy. So you don't have to do anything else at this time. I'll get some paperwork that will stay in. If it gets reopened, then we'll issue another date. All right. All the best to you, ma'am. Thank you, counsel.
Thanks, Judge. I have one more.
Yep. So that's
That one is Arrow versus Williams.
you know, I'm looking for LBA funds. This is case number. Case number 101056669. This is Arrow Financial Services versus David Williams. The matter is set today for a review. It's like, all right, very well. I have to set for review. Your appearance for Arrow Financial. Please.
Good morning again, Your Honor. Attorney Ashley Notice Hartman on behalf of plaintiff P77029.
Thank you. Good morning to you again. I'm looking for David Williams. If you're on the Zoom, Mr. Williams, please say something at this time.
David Williams present.
All right, thank you, Mr. Williams, and good morning to you.
Good morning, sir.
The last thing that I see on this was a motion to set aside Madam Counsel, any information that you have regarding this?
Sure. So we were here for an objection to garnishment. at the last hearing. The garnishment was denied as invalid. However, there was an installment payment order that was set up. So that's been ongoing. And then the court wanted to adjourn for a review to see if the parties could work out a settlement agreement. So we have been in contact with the defendant. We offered a settlement and he refused it. And so we have no agreement. And obviously plaintiff is just going to move forward as is.
Looks like the garnishment that was issued, I reduced the garnishment amount to $50 per week.
Mhm.
That's like that. All right, so you weren't able to reach an agreement. All right, Mr. Williams, anything you wanted to say at this time, sir?
Yes, sir. The reason that I denied it is simply because they don't want to give me credit for what I've already paid. And the amount that they are offering to settle for, if you add on what I've already paid, I'm basically paying the same thing.
All right, so did they send you an accounting? Did they send you how they calculated the numbers based upon interest and everything? Have you received that?
No, sir.
No, and the issue, judges, I'm sorry, Judge, I didn't mean to interrupt.
Yeah, what I wanted to say is issuing, giving a notice regarding the accounting to show from the date the judgment was entered, payments received, et cetera. That's a good starting place. Obviously, the parties don't agree on dollar amount in terms of trying to resolve it. I was hoping that whether it's paid that they might be able to do it, but I can't force that issue. That accounting thing.
Yeah, and Judge, we'll send him an accounting, but the issue wasn't so much the amount, it was the fact that he wanted what he already paid to be put towards his settlement amount. And we're telling him, no, you're trying to settle the remaining balance, not, so that's why there's no agreement. He wants the payments he's made already to be credited to the settlement amount that we provided him for the remaining balance. So that's why it's not working out.
And I think further that obviously the problem with this case is that, of course, the judgment was entered in 2010, and you had accrual for the last 15 years or so. And I'm sure that what Mr. Williams is saying is that he paid the $1,800 already. The problem is that it was paid over a 15-year period. That's the problem. And it means that there was additional money that was growing on that 15-year period. So I obviously, my desire is that the parties compromise on some of the interest that's approved. But again, that's up to the party. I can't force that issue. Because it had gone on for so long, I thought the parties might be able to reach that. But you can't reach that. There's nothing I can do on that part. So I'll order that the accounting be submitted within the next 21 days. And beyond that, that will be the case where it is. I wish the parties well. All the best to both sides.
Thanks, Judge. Have a good day.
Thank you, sir.
All right, and I'm aware of the parties here with the interpreter. I'll be right with you in a moment. Right now, the court calls 2424-06-76. This is Kelly Walker versus Baseline Diagnostic and Auto Repair. The matter is before the court. Looks like on the motion for reinstatement. All right, your appearance for Baseline, please.
Jessica Blanche, P74837 on behalf of the defendant.
All right, thank you, Ms. Blanche. Good morning to you, counsel. I'm looking now from Ms. Kelly Walker. Ms. Walker, if you dare say something at this time.
Morning, Your Honor. Yes, I'm here.
All right, thank you, and good morning to you, Ms. Walker. All right, so it looks like this case was dismissed. I believe when the defendant, tried that the defendant did not appear for a hearing that was set up by the court. So tell me why the matter should be reinstated, Mr. Walker.
Well, Your Honor, you already reinstated it. I made a mistake and filed a motion over the answer, and I was unsure what to do downtown because they sent it back to me saying that I didn't pay for it to get reinstated with you or whatever, but that wasn't the case. The case was you reinstated it and you gave me time to answer back. And when I done my answer, it should be up under there. The paperwork should be up under there to the answer, but when you're downtown, you can't ask any questions. So I was unsure whether to make it as the motion word because that's the letter that they sent me, or was I supposed to put answer to what the judge wanted me to answer back to, that you reinstated us for the last court date that we had?
All right. Thank you, ma'am. Thank you for the updates as well. All right. So it looks like the court did reinstate the matter and then required that there be an amendment or a supplement to the complaint that was filed in this matter. I received a document entitled "Motion for Damages and I believe that appears to be a document offered as a complaint in this matter. Madam Counsel, your position regarding this matter.
Judge, we never received service of the complaint. We did reach out to Ms. Walker because we saw in the Register of Actions that there was some type of something filed. So we did reach out to Ms. Walker. She was kind enough a couple of days ago to send us her motion, which we assumed is her complaint. We did the best we could with just acknowledging we received it and answering it, Judge, but I would ask for an extension so that we can actually file an amended answer with affirmative defenses. I don't have her full complaint because there was exhibits attached that we have not received yet. So I'd ask for time and get the full complaint so then we can answer it appropriately and put any affirmative defenses we have in our answer.
Obviously, a couple of things. One is that Ms. Walker did not submit a proof of service regarding sending these items to counsel, but now thanks to the counsel reaching out, she sent some documents. You want to make sure you get all these documents over to the attorney. But moreover, the motion is not in proper form. And a lot of times we try to not in that form be more important than substance, but basically, Ms. Walker, you really didn't provide an answer because you didn't label it as such and all of that. I should say a complaint because you didn't label it as such. And so those kinds of things cause other kind of problems. So what I will do is I will receive and accept these documents as your amended complaint, although they are labeled motion for damages, motion for relief, and then I will give time for the parties to resolve any issues or pieces that might be missing, so that the plaintiff is ready to have an opportunity to respond to the complaint in writing, and I'll set forth a hearing date for the parties to come back in front of me and see where we go from there. I would point out some of the things that I observed here as a part of the complaint, that this case, the allegations of damages in this case center around the offering of a vehicle for repair and the claim that the vehicle was not properly repaired, and the request for reimbursement. That's really what this case is about. The allegations of discrimination and all those kind of things. It's not really on the part of this case. This case is about damages claim as it relates to the claim of negligent repair of the automobile vehicle and the need for either reimbursement or to payment that's the issue in this case. The fact that someone got into a dispute, someone may abuse bad language and stuff, other issues like that, that really doesn't seem to be issues that can be raised in this type of case. But I'll leave it to parties to answer, and then we'll go over there. So I'm going to order the answer be provided 21 days, and the amendments regarding answers be made within 21 days. I'm setting that out. Then for the 5th of June.
Judge.
Excuse me, Your Honor.
No, just one moment, man. The 5th of June. The 5th of June is when the answer has to be filed. And then I'm going to set the next action date in this matter for the 19th of June. Can we do it then? Or that date? Is that?
We're closed.
Oh, we're closed. Can we do the 18th? Mm-hmm. All right, so the 18th of June will be the next hearing date in this matter. That will be at 9:30, June 18th at 9:30. Ms. Walker, you had something?
Yes, are you saying that I need to redo my answer, or they have to send me something back? Because you were going in and out.
Yeah, they have to answer the documents that you submitted. So I did a couple of things. I'm treating the documents you submitted as your answer. Which
okay, thanks.
That's a hard way to do it, but we're gonna do it that way, and they're gonna respond to that as your answer, right? And they have until the 5th of June to put in their response or their amended response to your complaint. And then I'm setting a hearing date on this matter for the 18th of June. That's when the parties will be back in front of me, and I will see what the case is at that time and make decisions as to how we move forward.
And Judge, I know that she's representing herself. Is there any way we can do an order so that she can serve us via email? Because that may be easier for her. And because we do need the exhibits that she attached to the her motion, her complaint. We don't have those.
Yeah, so I will allow service to be made via email. So Ms. Walker, whatever you attach to the items that you call motions, need to make sure that you communicate that information. Ms. Walker, you still there? Ms. Walker? Somehow, I think she got disconnected. So, so counsel, my order will allow her to serve in the way that is indicated. And I've already set on the record the dates where things have to be done.
Okay, thank you so much, Judge.
Thank you. We'll see you on the 18th.
All right, thank you.
All right, Ms. Walker. So you're all set, ma'am. You come back on the 18th and make sure you have I've given you the right to go ahead and serve by simply emailing stuff to the attorney for baseline. All right, good day to you, ma'am. All right, we're on the record now. On the recall of case number 24159, CR534. That's Calvary SPB versus Antonio Alvarenga. And I believe that there is an interpreter on this particular file. And so please indicate who you are, Madam Interpreter, for the record.
Yes, Vivian Montero, Court Interpreter 18369.
You are interpreting regarding Spanish, is that correct, ma'am?
That's correct.
Raise your right hand to be sworn. You do solemnly swear or affirm that you will interpret the truth from English to Spanish and Spanish to English to the best of your ability. So help you God.
I do.
All
I
right,
do.
Thank you. And counsel, your appearance at this time for
Yes, Your Honor.
Licenciado, su comparecencia en este momento.
Yes, Your Honor. Christopher Royce, P49102, on behalf of plaintiff.
Sí, su señoría. Licenciado Christopher Royce, cédula profesional P49102, por parte del demandante.
Thank you. And good morning to you, Mr. Alvarenga.
Buenos días a usted, señor Hernández Alvarenga.
Buenos días, señor juez.
Good morning, Your Honor.
Thank you. All right, so we are here for a status conference and a motion hearing regarding this matter.
Estamos aquí para una audiencia de control sobre el avance del caso.
Sí, está bien.
Yes, that's fine.
Mr. Royce, where are things regarding this matter? I know, I think the motion was for the interpreters. So update me, sir.
Señor Royce, ¿dónde estamos referente a este caso y el pedimento que se había presentado?
Yes, Your Honor. My understanding that the motion was just to, that Mr. Alvarenga was going to be out of country, and it was just to adjourn the original pretrial conference. Am I wrong in that?
Su señoría, yo creía que el pedimento fue porque el señor Hernández Alvarenga iba a estar fuera del país y fue simple y sencillamente para aplazar la preconsulta ante el juicio, ¿o me equivoco?
Yeah, I'm not sure, counsel. It doesn't look, yeah, I do see that motion, yes, and I set the new date for today's date. Thank you for that update.
Veo el pedimento, licenciado, y sí, fijamos fecha para hoy.
So this case is about a claim of damages in the amount of.
Este caso tiene que ver con daños por la cantidad de.
The amount is $5,775.02.
Por el monto de $5,775.02.
Sí.
Yes.
Are the parties able to discuss this matter, to talk about a way of resolving it?
Las partes han podido conversar o pueden conversar para ver si pueden llegar a una resolución.
Yes, Your Honor.
I'm sorry, two people speaking. Could you kindly repeat again, sir, attorney?
Oh, I just said, yes, Your Honor. I'm available to speak.
Sí, su señoría, estoy disponible para hablar.
I would like for Mr. Alvarenga to have a conversation with Mr. Royce in a breakout room with the interpreter present. Are we able to do that, Mr. Alvarenga?
Me gustaría que el señor Hernández Alvarenga tenga una conversación con el licenciado en una sala para grupos pequeños. ¿Podemos hacerlo, señor Hernández Alvarenga?
Sí.
Yes.
I'm sending a notification to each person now for the breakout room. That will give you opportunities to go in and talk, and you can come back to the courtroom now.
Le voy a mandar una notificación, un cuadro negro en pantalla. Si lo puede presionar la parte que dice join, vamos a pasar a la sala para grupos pequeños. Pueden conversar y luego pueden regresar.
Ok.
¿Lo ve ahora? Ya apareció en pantalla el cuadro negro.
Oh, ok.
Hay que presionar la parte que dice join. Thank you.
For Mr. Portner's office, is Mr. Portner there at this time?
Let me try giving him a call again, Your Honor. I just did and he didn't answer, which means he's usually in front of a judge, but let me keep trying. I apologize.
All right, not a problem.
Oh, yeah, he was asking, he brought this down with table this, he said this case is, the attorney.
Got it.
Okay.
All right.
Versus five. I need,
Oh,
I need to
fine.
file a verify.
Oh, okay, all right. Okay, all right, okay.
Okay, so what he's alleging is that the song is expired.
Yeah, he came down here yesterday, and he got about some, I said. Yes, yes, right.
Did you,
I said,
did
you
you
bring
get
it
a
down.
trade?
Yeah, I said, you bring it down. Yeah, I said, no, that's good for the block or something. We can't give you come.
Excuse me.
And you don't think I know that you're there? Don't you see me talking somewhere else?
Oh, I'm
So just-
sorry, Your Honor.
Yeah, chill for a minute. Now you see me talking to somebody else. Can you
I
excuse me?
didn't know. It just popped back on.
I'll probably be right with you. So yeah, I mean, you don't have to.
So I'm gonna hold that file.
Yeah, I just need to be there because he's right. If the summons had expired before the service.
Yeah,
Yeah.
that's what I told him. Do it, that's on the property.
Yeah.
Don't just tell me, don't talk to me, you can't do it that way. And I said, it's a private, let the judge know any change. You know, we have to.
Yeah, I mean, you shouldn't have to You should have done that. You know better.
Yeah, he asked me. I would just say, yes, I was just pick off.
Right. All right, Ms. Walker, I told you already that your case has already been, set up. They got an answer, they got a file your answer, you got to come back to the court on the 18th of June.
Okay, I didn't get, excuse me, I didn't get to hear anything because my phone went hot and went dead.
I know, but I'd already told you that before your phone went out and went dead. And
but it was going in and out, Your Honor. I was trying to explain that to you. I couldn't hear anything that y'all were saying because you were going in and out.
yeah, well, you know, listen, you knew that you come back on the 18th, right?
Okay.
And you also, they have to answer by the 5th. I already got you covered. I'm not gonna let anything happen that just happen without you here. Okay, we already covered that. So,
okay, thank you.
Change. So I'm treating your motion as answered, and they got as complaint, and then they got to file an answer to that by the 5th of June, and then you come back to court on the 18th at 9:30. And you'll get some paperwork in the mail from me regarding the court date. That's the date, the 18th at 9:30, 18th of June. Right? You all set?
Yes, sir. Thank you. Have a good rest of the week.
You too, Ms. Walker.
Okay, bye-bye.
All right, we're back on the record regarding the suffix 9450. And thank you to each of the parties to that church. Mr. Royce, if you will update me regarding the status of this one.
Estamos convocando nuevamente el mismo caso, licenciado Royce. Si usted me puede dar información actualizada sobre el caso.
Yes, Your Honor. We were unable to resolve the case. I think we're just going to need a discovery order and a motion for summary judgment date, Your Honor.
Su señoría, creo que no podemos resolver el caso. Creo que necesitamos una fecha para la próxima audiencia y luego una orden judicial de resumen sobre el caso.
All right, thank you for that information. I'm going to set this up on a pre-trial schedule with a return date of July the 21st.
July 1st, Your Honor?
No, July 21st of 2025 at 9:30.
Entonces, la próxima fecha de comparecencia es para la preconsulta ante el juicio, que es fecha de 21 de julio del 2025 a las 9:30 de la mañana. Again, by Zoom, Your Honor.
Yes, by Zoom.
Nuevamente por Zoom, por el mismo código.
I will send that order out in the mail.
Voy a mandar la orden judicial por correo.
And that order will allow for discovery of
Esta
information.
orden va a permitir el intercambio de pruebas.
It also has paragraph 6.
También en el párrafo 6.
And that paragraph allows for filing of motions.
Ese párrafo permite presentar un pedimento.
I will see the parties on 7/21/25 at 9:30.
Les vuelvo a ver las partes. El 21 de julio del 2025 a las 9:30 de la mañana.
The dates of both sides.
I'm sorry, Your Honor.
The dates of both sides.
Que va a comparecer en esa fecha para ambas partes.
All right, that's the end of the hearing.
Se levanta la sesión.
Thank you.
Ya se puede retirar. Thank you, Your Honor. Have a good day.
You too.
So let me know, when you, reach by Mr. Porter, because that's the only matter that remains in front of me at this time.
I appreciate your patience, Your Honor. I've been letting him know you're ready for him.
Thank you. Make it up for yesterday, huh?
Yeah, that's all that on there. I was like, it's all them summons though. That's what it is.
Yeah.
Yeah, Judge, you ain't gotta look at these people's files no more.
No.
Man,
That is one of the things.
yeah, that's a good thing. Too. Mhm.
You're gonna miss those files, aren't you, Judge?
Don't miss it. Like,
What'd you say?
we all picking up the night, figure out why.
Yeah, right. You ain't gonna be thinking about this place not another day.
Why is this happening to me? This happening to me?
Oh, wow.
And it was at 26.
Oh, dang, we said, oh, that like hard roadway.
So Judge, is it the 30th of this month or next month?
Next month.
Okay. Talking to Ross.
What you said here?
I'm talking to Ross. Texting him. Used to be your court officer. He always asks about you.
Who you talking to? Which court officer?
Ross, remember you used to be your court officer, Ross?
Oh, yeah. Okay.
And he asks about you all the time.
You been doing okay?
Yeah, he's not here today, but. Mm-hmm.
Yeah, that's my buddy there.
Mm-hmm.
And all this for everything. Yeah.
What is?
No. Yep. Two chairs, you got the one that turn it. No, just two. I don't know what happened to the. Standing up. Okay. Hi. Hi. Uh-huh. You go ahead. Mhm. Yeah. You want a second summons, so you have to send in if you want a second summons, you send in the motion. You want the first paper that says motion for second summons. So the judge should sign at the bottom, and then you're gonna send it a summons with it, so it's together, the motion for second summons and the summons. That's for you to do the second summons, so you have to have proper paperwork. Mhm.
Your Honor,
No, he-
Mr. Fortner's logging on right now.
All right, thank you.
You didn't have the proper
Okay.
paperwork. Said second summons. That's motion.
We are on the record regarding the suffix 2647. That's Rodney Chiropractic versus Citizens Insurance Company of the Midwest. Today's date time set for a pre-trial conference in this matter. Also have a notation that is to be reviewed on today's date. All right, your appearance for the plaintiff.
I don't think he's on yet, Judge. She said he was coming on.
Oh, I see. I see.
Okay.
All right, we are on the record in 2647, Rodney Chiropractic versus Citizens Insurance Company of the Midwest. Your appearance regarding this matter for plaintiff.
Yeah, Mike Porter is here, P46541, Your Honor, on behalf of plaintiff. Thank you.
All right, thank you, Mr. Porter, and good morning to you, sir. I don't see the other side on this. I did call this earlier, and they were not here.
I talked to her, Your Honor. She was at the doctor with her daughter. And so I told her I would tell you and ask you if you'd be willing to maybe kick this 2 weeks. I think we're only about $1,000 apart. So if the court would be willing to give us a short adjournment, we might be able to have this thing resolved and not have to bother you.
All right, Mr. Porter, I will do that. I will go ahead and adjourn it over till the 29th of May, 5/29, 25 at 9:30 a.m. And that will be the next action that we'll be giving that effect.
Thank you very much, Your Honor. I was downstairs with Judge Garrett, Your Honor, and I lost track of time, so I apologize.
Not a problem, sir. All right, we got it.
All right.
We got it.
And thank you for waiting for me. All right, thank you. All right, bye.